Our first case this morning is Heien versus North Carolina. Mr. Fisher?
Mr. Chief Justice, and may it please the Court, in a country dedicated to the rule of law, governmental officers should be presumed to know the law at least as well as the citizens are. That being so, when questions about individualized suspicion arise under the Fourth Amendment, they should be addressed against the backdrop of the correct interpretation of the law, not simply any plausible reading an officer might have.
So suppose that this state, North Carolina, did have a good faith exception to the exclusionary rule. What would you be arguing today?
We would still be arguing, if that were the case, that not only the Fourth Amendment was violated, but that the good faith exception didn't apply. But you wouldn't have to reach that question in this case. And I would concede to you, Justice Kennedy, that would be a debatable argument.
Why would it be any more debatable than the argument you're making here? I more or less anticipated your answer. I think that has to be your answer. I think you have to tell us, even if the good faith exclusionary rule applies, a mistake of law just doesn't count.
Well, that's not exactly what this Court's jurisprudence holds, of course. In Kroll and Davis, the Court has held that reasonableness of mistakes of law can be taken into account at the remedy stage. And I think that would be...
But then the question is, why isn't that a problem for you when you say there cannot be a reasonable mistake of law? We know there can be.
Mr. Fisher, I have a preliminary question. Even if you're right about mistake of law, isn't it a moot question in this case? Because as I understand it, the traffic stop ended with a warning citation. So the traffic stop is over. And at that point, the police officer asks if he can inspect the car. And the answer is yes. Why isn't the consent to the search the end of this case?
Because it would be the fruit of the poisonous tree, Justice Ginsburg, if the stop was illegal. There would have never been an opportunity to ask for consent. And I think that's why the State and the Solicitor General haven't made any argument that the consent wipes away the Fourth Amendment question here.
Well, suppose the officer had said, all right, I'm giving you a warning. You're free to leave now. But by the way, may I search your car?
I think that's more or less what the officer did say here, Justice Alito.
And you would say that, even in that situation, that that would be the fruit of the poisonous tree?
Yes, because the stop wouldn't have taken place. The Court's cases, Prus and all the rest, say that a traffic stop is a seizure. And so upon pulling Mr. Heien over, the officer needed to have reasonable suspicion to do so. And the only argument for reasonable suspicion is the mistake of North Carolina law as to the brake light in this case.
I understood you to say earlier that you don't take, distinguishing the exclusionary rule and qualified immunity, you don't take reasonableness into account when it comes to a mistake of law.
I'm sorry, Mr. Chief Justice, what I think I said is that you don't take the reasonableness of mistake of law into account when you ask whether the Fourth Amendment was violated.
But the Fourth Amendment itself protects only against unreasonable searches and seizures by its term. It seemed to me that there's a stronger argument for taking the reasonableness of the officer's actions into account.